From Victor Zammit, pictured. Commentary on Science and the Law. The objectivity of objectivity. Just how truly objective are scientists? Some scientists are using the word objective about their work when they are not being really objective at all. For example, why is it that there is fundamental disagreement among physicists and cosmologists about the origin of the universe? Why is it that there is one flamboyant scientist who vehemently states that the universe began with protons creating themselves, but other scientists do not agree with him? Why is it that the more objective scientists confirm the existence of the afterlife and the paranormal after investigating them, but materialist scientists continue to refuse to even investigate the evidence? The onus is on the materialist scientists to rebut the overwhelming evidence for the paranormal and the afterlife. But in over 100 years, no genius materialist scientist, no genius closed-minded skeptic has done so. But there is a way to bypass the scientific rationale to arrive at the truth, the whole truth, and that is legal reasoning. Here is where legal reasoning shows law to be superior in flushing out intervening negative prejudices and other lackings of objectivity with some scientists by way of sharp cross-examination. When scientists disagree in science, it means the specific scientific dispute has to be sharply tested. Negative prejudices of the scientists inevitably encumber true objectivity in scientific experiments. One of the critical principles is the experimenter effect, where the strong prejudices of the experimenter influence the results of the experiment. Encumbered perception. There is also a big problem with materialist scientists who have an encumbered perception, where they cannot perceive any information which is inconsistent with their cherished materialist beliefs. Courtroom science and the afterlife. Why attorneys are just as important as scientists. It may shock some people to learn that litigation, court procedure, especially in cross-examinations, is just as important as physical science when it comes to proving the existence of the afterlife. Cross-examination is more than just an art. It has certain empirical principles, the way scientific method has. Normally, scientists conduct experiments and indicate what the results are. Then the scientist interprets the results and writes a paper which sometimes is peer-reviewed. But in controversial areas of science, the credibility and the prejudices of the scientists working in the field and the credibility of those who oppose their results has become an urgent, critical issue. Testing the credibility, the prejudices, and degree of expertise of an expert witness in science is a standard task for barristers, who know that the outcome of many a trial depends on the testimony, sometimes, of a single expert witness. Recently we have seen how scientists working in studies sponsored by the pharmaceutical industry have allowed their prejudices and vested interests to influence their findings. According to Anesthesiology News, the Wall Street Journal, and the New York Times, in 2009, Scott Rubin, a prominent Massachusetts anesthesiologist, was found to have allowed his scientific prejudices to fake data used in 21 studies, which were published in several anesthesiology journals between 1996 and 2008. Scientific American has called scientist Rubin the medical equivalent of Bernie Madoff. A growing concern with fraud and misconduct in published drug studies has led researchers at the University of Illinois at Chicago's Center for Pharmacoeconomic Research to investigate the extent and reasons for retractions in the research. In May of 2012 they released a report which analyzed an alarming increase in the number of journal articles in drug literature which are later retracted. Nearly three-quarters of the retracted drug studies were attributed to scientific misconduct, which includes data falsification or fabrication, questionable veracity, unethical author conduct, or plagiarism. In July of this year, UK-based pharmaceutical giant GlaxoSmithKline, GSK, pleaded guilty to criminal charges in the USA, and was fined $3 billion, in what even the mainstream media is calling the largest healthcare fraud case in history. A 9-year legal federal investigation has exposed GSK's rampant abuse of the law by illegally marketing drugs, forging drug safety data, bribing doctors to promote dangerous and expensive drugs, ripping off Medicare and Medicaid, and lying about the effectiveness and safety of drugs. It was the legal process which flushed out the fraud by the scientists. The legal process of cross-examination is one way, of testing the expertise, credibility, and motives of a scientist witness. But when I refer to cross-examination, I refer to those attorneys who are experts and have full knowledge of the empirical rules of cross-examination, which are akin to the empirical rules of scientific method. There are many lawyers who never in their life cross-examined anyone, because they are not attorneys. They never worked the courts, in the lower or the higher courts. They work in legal offices in different administrative areas of law. Non-litigation lawyers are not experts or competent in cross-examination, and usually do not know the empirical rules. I give one example to illustrate how critically important competent cross-examination by attorneys is. During the Nuremberg trials in 1945, Hitler's successor, Hermann Goering, was cross-examined first by American lawyer-politician Robert Jackson. This American former attorney general made a mess of cross-examining Goering. Jackson showed he did not know the basic empirical laws of cross-examination. He was playing a politician there, not an attorney, when cross-examining Goering. That was fatal. Historians tell us that Goering made Robert Jackson look silly. But then a highly competent British barrister, senior attorney, expert in cross-examination, Sir David Maxwell V, was called to take Robert Jackson's place. He had an impressive courtroom record, and made Goering look absolutely ridiculous, cutting him to shreds by brilliant cross-examination. Sir David saved the day for the free world, and showed he was a master of the empirical rules of cross-examination. When it comes to the issue of the evidence for the afterlife, the skeptical, physical scientists would be the so-called expert witnesses. They would be cross-examined on the extent of their knowledge and prejudices. In a famous relatively recent Australian murder case where the mother Lindy Chamberlain was accused of killing her baby daughter, it was her barrister whose incisive cross-examination showed that the expert testimony of the police scientist regarding the blood samples found was all wrong. The accused was subsequently freed from all guilt. Critical to the legal procedure, and something which is not disclosed in scientific reports, is whether the scientist refuses to answer critical testing questions. This is most vital, because in the courtroom the scientist witness is sworn to tell the truth, and if the witness is caught lying, or refuses to answer a question, the witness could go to prison. Here's an example of a part of a hypothetical cross-examination of an anti-afterlife, closed-minded, skeptic scientist. Attorney: do you accept there is an afterlife? Yes or no? Skeptic: no, there is no afterlife. Attorney: what evidence do you have to say there is no afterlife? Skeptic: I don't think there is any evidence for the afterlife. Attorney: I did not ask if there was any evidence for the afterlife. I asked what evidence do you have to say the afterlife does not exist? Skeptic: I guess there is no evidence proving the afterlife does not exist. Attorney: are you aware that there has never been a book written by a scientist or anyone that there is not or cannot be an afterlife? Skeptic, hesitating: yes, I'm aware of that. But? Attorney: no buts. That called for a yes-no answer. Have you ever read books by highly credible scientists confirming that there is an afterlife? Skeptic: there are no real books by scientists about the afterlife. Attorney: have you ever investigated the afterlife evidence? Skeptic: no, never. There is no evidence. Attorney: have you ever taken the time to read books by the scientist Sir Oliver Lodge on why he, after investigating the afterlife, accepted the evidence for the afterlife? Yes or no? Skeptic: no, I have not. Attorney: have you taken the time to read any of the books, mostly by scientists, which clearly explain the afterlife evidence, like Professor Fontana's famous work, Is There an Afterlife, and the books by Sir William Crookes, Sir William Barrett, Arthur Findlay, some 50 more books mentioned? Skeptic, hesitating: no, I have not read any of the books you mentioned. Attorney: no, you have not. Why then would you come to a conclusion about something of critical importance before you investigated? Skeptic, not answering. Attorney, looking at the judge: could you tell this witness, Your Honor, he has to answer the question? Judge: yes, yes. To the skeptic: you must answer the question. Skeptic still refuses to answer the question. Judge: If you do not answer the question, I will hold you in contempt, which means you could be locked up until you decide to answer the question. I, Supreme Court lawyer Victor Zammit, have put on my website 3 highly informative, entertaining and interesting hypothetical cross-examinations of 2 internationally known scientists and 1 flamboyant skeptic to show that cross-examination fleshes out the truth about the afterlife evidence in a way that conventional science cannot. I have added a qualification that I would be more than happy to hear from any attorney to show where, when, how, and why the cross-examination is unfair. In some 12 months since I put these cross-examinations on my website, I received heaps of positive responses even from American lawyers, but not even one negative. To view, go to the left column of my website, www.victorzammit.com. Leading arch skeptic pictured Ray Hyman and flamboyant James Randi have never faced cross-examination to establish their credibility. Thus they have no standing whatsoever